It's time for closing arguments in this medical malpractice case. If the defense attorney fails to address a key significant point during his closing remarks, can I now then pounce on it when I get up to make my closing remarks? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is absolutely yes, I can do that. You want to know why? Because if my adversary leaves out a key strategic thing, and now it's something that's so obvious, I want to now tell the jury and explain to the jury why the defense didn't even touch that argument, and why they couldn't touch it, and why they have no defense to that argument. And what that does is destroys the defense's credibility. If they clearly do not address something that's so significant in the case, now I have a clear opportunity, a clear opening to go after it and attack the fact that they didn't even talk about it. Attack the fact that they have no defense to that. Now, what you should know is that during closing arguments in a medical malpractice case, for example, the defense attorney will always be given the opportunity to go first. Not just given the opportunity, he will go first. So now the defense is going to go ahead, make his closing remarks, and explain to the jury why they believe they're entitled to a defense verdict. Then, when he's done, I then have an opportunity to get up, and I will actually have the last word about the arguments that are being made in this particular case. Naturally, the judge gives the jury instructions after the attorneys are done making their presentations about closing remarks, and he is the one who actually has the last word. But the way it works is that the defense attorney goes first to make closing remarks. I then have an opportunity to get up after him to now give my closing remarks. And when I am done, the judge will then give jury instructions to the jury to let them know what the law is in this particular case. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on during the trial process in the state of New York. This will happen from time to time. And I realize you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.